When is it likely a court will order supervised parenting time? My name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues right here in the state of Michigan. Today, we're going to continue in our video series designed to educate and inform the public. So please subscribe to our channel. When is it likely that a judge is going to order supervised parenting time? Well, I'll tell you one thing. It's not the default position. The default position is you have parenting time with your child, dad. You have it with the mom. We're not getting involved. Enjoy. Have a wonderful time. Bring the child back on time. That's all the court cares about. Every now and then, somebody will say, I don't trust them to do something in the best interest of the children. I insist on supervised parenting time. Well, you're going to have to show the court a reason why a third party should be involved in this, why somebody should pay that it should be done in a facility. You're going to have to show the court why somebody should have to go through that expense. And the only way to do it is to show that there's a proven risk to the child associated with the parenting time. You're going to have to, for example, show a history of untreated drug or alcohol abuse. That is likely that the guy, has 6 drunk drivers, he's going to show up drunk. He's going to be intoxicated or on drugs. You're going to have to show that. You're going to have to show that there's a compelling reason why standard parenting time poses a risk to the child. A recent history of domestic violence where perhaps the violence was done to or in front of the child. That might get you some supervision on a temporary basis. These kind of things. Severe, untreated mental health issues, that could be part of it. There's got to be a real risk. Parental kidnapping or abduction is another basis why you might add that. Here's the bottom line to what I'm saying. If there's a risk of abduction, if there's a risk of exposing the child to drug use, to criminal activity, to alcoholism, to domestic violence, look at these things. Look how severe these are. These are the examples of severe things for which the court may say, you know what? I'm not comfortable with an unsupervised environment. I've got to put some safeguards in place. It's got to be those kind of things. It can't be just like I see in so many cases where there's a divorce and all of a sudden mom files a thing. I don't want the dad to have unsupervised. I don't trust him. You didn't trust him? Well, when you were out getting your hair done at the salon over the last few years and left the kids alone with him, you trusted him then. When you wouldn't have girls night out, you trusted him then. Now all of a sudden you don't trust him? No, it's not going to be like that. The court is not going to fall for that manipulation. Okay, so if that's what you have in mind, forget it. On the other hand, if you're really worried about the concern, safety concern of your child because of a drunk driving, an unchecked domestic violence or a drug abuse, that kind of thing, where there's anger management issues, substance abuse, I get it. Somebody's just abusing alcohol or drugs. I get it. That makes sense. The court can grab hold of that and side with you. But it's got to be something significant. You got to make sure that the court's not getting the impression that you're doing this just to jockey for position out of spite, because the moment the court thinks that is the moment you're losing that motion. So bear that in mind. If you have any questions about your case, reach out and we'll be glad to help you out.
248-5888